Good morning, good afternoon, and good evening to everyone, wherever you are viewing this from. I'm Neil Henderson, a member of the London Shipping Law Centre Education Subcommittee and a barrister at Four Pump Court. On behalf of the Chairman of the London Shipping Law Centre, Dr. Aleka Shepherd, and on behalf of Four Pump Court, I have great pleasure in welcoming you to this, the 10th in the Global Webinar Series for 2021. We have a first-class panel lined up to speak to us today, covering both practical and legal aspects of negotiating contracts. Almost 400 people have registered for this webinar, including from Australia, Brazil, Nigeria, Singapore, South Africa, and Turkey, which illustrates what a relevant and important topic this is. Chairing our panel this evening is the Honourable Mr. Justice Foxton, a judge of the Commercial Court, who I'm sure many of you will have appeared in front of or instructed when he was a barrister at Essex Court Chambers. Sir David has vast experience of shipping and international trade, with 30 years experience at the bar before becoming a full-time judge in 2020. He has quite literally written the book on it as the main editor of Scrutton on Charter Parties and Bills of Lading. What you may not know about Sir David is that he is also a biographer of Scrutton and that he wrote a PhD on the work of the English judiciary during the Great War. Thank you very much, Sir David, indeed, for chairing this event. I'll now hand over to you to introduce this evening's event and the panelists. Thank you.
Well, thank you for that very kind welcome, Neil, and it is a great pleasure to chair such an interesting seminar. The topics tonight are areas, I think, where the cut and thrust of commercial negotiation run into legal doctrines of contract law, and those are not always happy collisions. The first time when I had to engage with these issues, I have to say, was in the early 90s as a very young barrister, grappling with the then Mr. Justice Staines decision in the Junior K on subject details. And that was followed by a case in which the parties had managed to carry on negotiating the details for 6 months while the reefer vessel performed through the high season, at which point, when business looked rather scarce, the putative charterers said, well, there's no point in negotiating anymore, and what's more, we never had a charter party. So the conflict between law and commercial expectation was one that I was aware of at a very early stage. More recently, I've had to engage with this issue in a case called the Leonidas, which I know that Alex is going to be talking about in due course. It is, I think, a context in which the lawyer really benefits from understanding the commercial context. And for that reason, we are very fortunate this evening to begin this event with a presentation giving us that context from two experts in the field. Catherine Jago has over 38 years experience on the commercial side of the oil and shipping industry. She often acts as an expert witness and arbitrator with expertise in oil and commodity pricing, trading, hedging, and shipping. Max Beckett provides strategic advice and risks and project management across the energy and commodity sectors. He too has great experience of the energy and shipping sectors going back 25 years. So they are going to give us the insider's view on how oil trades are agreed and implemented, the use of hedging and price management tools, and a subject which is always of the greatest interest to lawyers, how these deals can go wrong. So over to Catherine and to Max.
Thank you very much, Sir David. We'll attempt to cover all of those topics in the very short allocated time that we've got. And it is a huge subject, but we will do our best, and we encourage you to add your questions through the chat facility, and we will do our best to answer them, probably, I believe, at the end of all the talks. So I wonder if we could go to the first slide, please. Just so that you know, Max and I are going to do a bit of a double act here. We will work together on this. The first slide is just a place setter really to show that if you look at prices over the last 160 years or so, that actually the real crude price has been hugely volatile. It's not that different. Right now, it's probably about $70 or $80, something like that, depending on the crude that you're looking at. Next slide, please. There have been a lot of changes in the market over the years, certainly that both Max and I have been involved in trading oil. I'm not going to go through all of these, but the most significant ones are, I think, that the price risks and the way that they are now managed. And active management of price risk through things like hedging and the use of derivatives is very much a key element of trading. We can't possibly cover this in detail in the 20 minutes or so that we've got allocated, but we want to give you just a flavour of what is used by traders to manage price risk. Next slide, please. Just a very simple point. You may not realise that crude oil in its own right has very little value. It's only when it actually gets refined into products that it has value. And it will be refined into various types of products. And when you're looking at a trading organization, they generally divide their trading departments in accordance with these products. Next slide, please. So you would usually have physical traders who would focus on crude oil or other parts of the barrel, say gasoline, the light ends, or the middle distillates, which will include the jet, or the fuel oil, the heavy part of the barrel. And also then there would be geographic teams. But the important thing nowadays is that that trading is global. And any trader has to work with traders in other areas to watch what's happening in the other markets. Not only do they have to work with other traders, they need to work with their middle and the back office to make sure all the operations go smoothly. And as I've already mentioned, they like to manage their own price risk. Now, this can either be done through an in-house team, perhaps, that may be allocated for doing derivatives. And that in-house team can, as well as managing the hedging, managing the price risk, they may also be speculating. Now, these two things are very different. If you're hedging price risk, you're trying to reduce the risk. If you're speculating, you're increasing the risk. And it's important to differentiate between the two. So what we're going to do is take you rapidly through the sort of processes that a hypothetical trader in a hypothetical company, we're going to call them Erasmus, and their distillate book. Distillate is jet, gas oil. We're specifically looking at gas oil today. And they have a US office, a London office, and a West African business development team. Next slide, please. So I'm going to hand over to Max, who's going to take you through some of these steps.
So basically, if you look at these two lines, and I'll try and do this relatively quickly, and I apologize if some of the detail is lost. But the blue line here is reflecting the price of buying gas oil in the US plus freight on a physical basis. And the orange line is reflecting what you'd expect to be selling that gas oil at in Europe. And you can see sometimes the blue line and the orange line meet. Sometimes it's more expensive on the blue line. Sometimes it's, you'll see the orange line like here, where it's you actually see an opportunity to buy low, sell high. Now, the problem you have is with all of this volatility and crisscrossing, the trader's going to have to sit there and wait till he sees a wide enough margin, which we call a spread, in order to be able to buy this cargo and then sell it at a profit. So in this situation on the 10th of June, and this timeline is actually for the duration of the deal we're looking at, the trader concerned knows that he can probably get a cargo of gas oil out of the US, and he knows that on this day, he can lock in a spread on the futures market, which allows him to sell this profitably into Europe. Next slide, please. There's three steps in any deal, for a physical deal anyway, the first step is to effectively execute a paper arbitrage. It's very unusual to have somebody buying a cargo and selling a cargo without any form of hedging. With the volatility we see in today's markets, that's potentially suicidal for a trader. The trader's interested in locking in that margin he saw and then trying to trade around it based on different geographies or different qualities. So in this step, he would execute, in number one, the purchase of the futures in the US, and he will sell the futures in Europe, effectively mimicking what he's doing on the physical trade, or intends to do on the physical trade. It might strike you that $520,000 loss on the paper market doesn't make a lot of sense, but then you have to look at the reality of where the actual physical is trading. And the physical cargo you're buying is always discounted to the NYMEX futures quote that you're hedging with. So effectively, the trader will know that that gap he has fixed. Now, by fixing it, he limits his downside and he limits his upside. But what he knows is that 200 grand here, which he potentially can make, is relatively safe. At this stage, he's going to look to buy a cargo, which is the main topic of our talk. So if we have the next slide, please. Once he's locked in his spread, he'll approach a broker, maybe another trader, talk directly to some of the refiners or blenders in the Gulf Coast to try and find the right cargo, the right specification of oil, which gives him the maximum opportunity to trade around into Europe. So he's looked at selling this into Rotterdam, but there's a potential market in the Med, there's a potential market in Africa. You may even see a ship go from the Gulf Coast all the way to Japan on a particularly unusual but opportunistic basis. Once he's found the cargo on the right dates, if he can find the cargo on the right dates, he'll then begin to negotiate the key terms. These key terms are going to be the price, the volume, and the quality on a commercial side. Once those are agreed in principle, he'll ask the supplier for a firm offer. He'll ask that offer to be valid for as long as he can get, normally a few hours. And that offer will generally be subject to contract and other terms and conditions. Hopefully, the time he gets will give him enough time to check the freight, check payment arrangements, go through the KYC, and make sure the rest of the terms and conditions of the contract are nailed down. Not a lot of time. In that time, whilst trying to finalize the other terms, agreeing whose general terms and conditions are going to be used, traditionally the sellers, but if he's buying from a smaller counterparty or a company he's not particularly comfortable with, he will try and insist on using his general terms and conditions. Not always possible, and it really depends who's holding the aces in this regard. If there's only one cargo, then you may have to give on the contractual terms. And you have to remember the traders, he wants to close this deal. He can see that he's making profit. And what he's not doing is thinking about the necessary ramifications of all of the minutiae that are effectively embedded into the contractual agreement. Once he closes the deal and buys the cargo, as far as he's concerned, the deal is done. It may well be subject to contract, but his mindset is now we're moving forward. If you're working with a regular counterparty, it's actually quite easy because your deal terms are on a last done basis where you've actually gone through all of the minutiae and the operations and contracts guys are happy. On a new contract, that's not the case. Next slide, please.
So what can go wrong? Well, from a trader's perspective, you may not be able to find the most appropriate cargo. In other words, one that matches the qualities that you want, that's available on the required dates, that's the right size cargo. And even if you can find it, the price, the premium for that desired cargo is too high. It's higher than you'd anticipated when you'd seen this opportunity. Now, the reason it may be higher is because there are several people who've seen that idea. And that is one of the changes. The market now is so much more transparent than it ever was before. So when this arbitrage window opens, there'll be lots of traders potentially who will be looking to take advantage of that. So there may be too many people chasing the same cargo. Of course, once you've found the cargo, you may not actually be able to do business with that particular seller. So there are a number of pitfalls before you've even been able to purchase the cargo. And of course, you also need to ship this cargo because your intention is to take it from the States over, at the moment, your intention is to take it into Europe. Next slide, please.
So the process of fixing a vessel is very similar to fixing or buying a cargo. You generally approach a broker. You may talk directly to owners that you have a good relationship with if you know they have a ship available. Once you've ensured the ship that you found and that you like is, you want to make sure it's suitable for all of the potential discharge ports you may go to. Now that's impossible to do. So you're relying on the trader having a solid background and understanding of all of the different ports that he could possibly trade around. In this case, the cargo is unsold, but we do know where it's going, where it's been bought. So we can clear the ship with the supplier. You negotiate the key terms, the discharge options being probably the most important. You want as many options as possible at as cheap a rate as possible. The vessel details and the demurrage rate. Once you get to a point that you're happy with the terms, and quite often you'll see that there's a trade-off between the number of options you get geographically and the value or the cost of each of those options. And that really is an assessment which, it's a probability weighted assessment the trader makes generally in his head. You then, you have your terms in principle, the ship's put on subjects basis, STEM, suppliers, receivers, management approval. As we discussed, we don't have any receivers here, so we don't have to worry about that. Management approval just means running it up the flagpole in the office, depending on who gets to take the final say-so. Generally, the trader can actually do that himself unless he's very junior. The STEM, as it's the supplier, if you're buying from a trader, the trader may go back to the refinery. So you could have a small chain there. You could have a long chain, it's unlikely. So you wait to get that approval through. During that time, you try and finalize all of the other terms, unless you have a last done deal with a set of terms agreed beforehand. You nominate the vessel to you agree internally that the deal makes sense. And then if everything lines up and you're happy, you'll fix the ship. The purchase, in this case, has already been concluded. There are times that the purchase may not have been concluded and you'll take the ship if there's very few alternative ships. And you have your cargo and you have your ship. Next slide, please.
So what are the potential risks in trying to fix a ship? Well, once again, there may be no suitable vessels on the dates on which you want to load the cargo. What you might do is go back to your supplier and see if there's any flexibility on the dates that you purchase your cargo on. That may or may not be possible. The suitability of a vessel can depend on various things. Obviously, it's a question of cost. Once again, you've anticipated in your calculation of the arbitrage opportunity what the freight costs are likely to be. If those freight costs go up too much, it may erode your profit. And indeed, this was one of the problems that happened last year when oil prices plummeted so much that actually the cost of freight was a much greater percentage of the cost of your deal than it would be now when prices have gone up. The suitable vessel, it may not have the right discharge options that you might want. There may be problems with the history of that particular ship. And there may be issues around the approvals that that particular vessel has got. Of course, there may be problems due to bad weather. I mean, these are all very common things. And also due to congestion at the load, and then potentially later on at the discharge port. But there are ways around some of these other things. And one way, if you happen to find a vessel that's too large, there are benefits on that, because obviously the freight costs are going to be a lot less if you actually fix a bigger ship. So you may look to fix a bigger ship and then purchase another part cargo to fill up the ship. And that is a good way of improving your profit opportunities. But you have to remember that there's this push from the owner to use their vessel as much as possible. And the chances are you're going to get the best deal from a ship owner who is sitting quite close to where you want to load, so they've got very little downtime. Next slide, please.
So here we see the planned route for the ship from Houston going into Rotterdam. It's a 16-day voyage. And if we just pay a little bit of attention here, the ship will pass between Charleston and Bermuda roughly around day 6. Next slide, please. Now, the interesting thing is that this profitability changes as the deal moves. So if you take say you've got 10 days before the ship loads, you've got 16 days to discharge port, that's 26 days. In those 26 days, your basis risks are moving. Now, here we see that around day 14, after the cargo is loaded, the market's moved and the P&L has actually gone up to about $386,000. This could have gone the other way. The trader's feeling happy, everybody's comfortable. They're monitoring the market. Next slide, please. Now, come day 6, all of a sudden, you've seen the prices in Europe have started to fall, but in West Africa, there's a lack of gas oil, and you've seen the prices are starting to rise there. Now, if you do a recalculation, you find that to deviate the ship is going to cost you an extra $100,000 in freight with the ship owner for the other option, for your alternative option. Can I have the next slide, please? However, the extra sales price you'll receive will give you a P&L of around $725,000. So that's what we would call a no-brainer. Effectively, the ship will be deviated to West Africa. And the nice thing with this is the West African gas oil market is bought and sold on the same European basis as where you'd be selling in Rotterdam, which means you're not taking any extra price risk and you don't have to change your hedges, which is pretty important. Next slide.
So your final P&L on this particular deal is $610,000, and a trader will be very happy with that sort of profit. I'm afraid the days of making the huge profits are long gone in general, and the margins that traders are looking at now are fairly small, which is why when things go wrong, it can be devastating, because it doesn't take much to erode a profit of this sort of figure. You only need to have quality problems, it's not loaded the correct quality, delays from the ship for other reasons, payment problems, delays on getting letters of credit. All of these sort of problems mean that that profit can be eroded, and that is not good news for any trader. Next slide, please. In fact, the example that Max has given really happened. And this is a sort of example that goes on all the time that traders have to be aware of. And that's why they need this level of flexibility. Next slide, please. So those of us who are involved in dealing with the problem ships and the problem trades think that this happens a lot. Most trades go smoothly. And in my experience over the years, it certainly used to be the case that rather than picking up the phone to your lawyer as soon as you had a problem, you'd actually pick up the phone to your trader on the other side and say, look, mate, we've got a problem with this. Can we find a way around it? And generally you could sort that out. Unfortunately, one of the changes I've seen over the years I've been involved is that doesn't happen anymore. And it does tend to be the first port of call is to the lawyer. And that is probably why people like Max and myself and many of the people on this webinar are so busy with dealing with not just oil, but other commodities. So the sorts of issues that we deal with are some of the ones that are listed here. Ships breaking down during the supply chain, off-specification delivery, it's supposed to be discharged against an LOI and it's being delivered without the bills of lading being presented, and so the bank is claiming missed delivery. And what we get involved in doing is how looking at how the damages for these sorts of issues should be calculated. And one of the key elements is the price risk and the hedging that needs to be taken into account when looking at commodities. And if there's one message we would love you to take away from this presentation is please consider in any claim where there's a loss associated with market movement, just consider whether there should be some hedging profits taken into account and vice versa. And this is particularly important with ship owners because many ship owners don't have the same information access that traders would do. And so when they are faced with claims from traders, they are at a tremendous disadvantage in trying to challenge those claims, particularly when it comes to market loss and hedging. So next slide, please. So that is a bit of a gallop through the subject. We would welcome any questions that you might have, and I think we have done it within our allocated time just. So thank you, Neil. I'll pass it back to, well, Sir David, I'll pass it back to you.
Thank you very much. By Council and the Commercial Court standards, that is exactly within your estimate. If only estimates were always so accurate. Now, our next speaker is Alex McIntosh, who will be known, I think, to most of you. He is a partner in the London office of Pennington's Manches Cooper, where he's a member of the firm's shipping and international trade teams. He advises on all kinds of disputes relating to charter parties, bills of lading, or other contracts in the international trade and transport field. He's got over 30 years of experience practicing in Greece, Hong Kong, and London. And Alex was the partner for the claimant in the Leonidas, the case that I mentioned earlier on, which I heard remotely last year. And that dealt with a number of subject to conditions. And it was a case that I thought raised a lot of interesting points and was extremely well presented on both sides. So I'm sure this will be a very interesting talk, and I'm looking forward to hearing, Alex, how I got it all wrong.
Thank you very much to David, and welcome to everybody today. I've never given a speech as a talk before where the judge who decided the case that I'm talking about is actually there. So whether I might be thinking that he got it wrong or he thinks that I've not correctly explained it, we will find out. And I was also noted the point that it wasn't myself, but it was one of my colleagues who was on the losing side in this case. And I just wondered whether the London Shipping Law Centre had deliberately brought us in with Sir David in order that we might engineer some sort of Jeremy Kyle friction. So we'll be probably just as well we're not in the same room, or we'll be throwing things and accusing each other of things. But perhaps we can avoid that. Can we have the next slide, please? So the details of this case. This was an attempt at a voyage charter party fixture to carry a crude cargo on the vessel. The owners were the party who became the claimants, our clients, Nautica. The charterers were Trafigura. There had been an extensive amount of discussion, and the subjects were, as Max originally said, subject to charterers' STEM, that is, subject to enough material, the suppliers' approval, the receiver's approval, and the management approval. Those have been reduced by agreement to subject to suppliers' approval at Aruba and Statia. The parties had agreed that the first, third, and fourth of those subjects will be lifted in return for the owners agreeing to reduce the demurrage rate, which would apply under the charter. So we had one subject remaining, and that was suppliers' approval at Aruba and Statia. The Statia terminal was operated by New Star, and the Aruba terminal was operated by Valero. Can we get the next slide, please? The cargo that was due to be carried on board, Trafigura were going to buy a cargo from Rosneft for the New Star terminal, but they had their own cargo lined up at Valero. So they wouldn't have had to go very far to get approval of that. Can we get the next slide, please? It was important in this case, because of a dispute that arose, to work out what suppliers' approval actually meant. And the judge went back to look at what all of the subjects in the case meant, because he believed that they would be properly reflecting one on another. And the question of whether there is a binding contract and on what terms would depend not on what the parties thought, but in fact what they had said and done. That's a key basic principle of English construction law, but it was important to restate it in this case for a couple of reasons. One is that there was a disagreement on the meaning of the subjects, particularly the supplier's approval. But it also transpired from some of the witness evidence that came out that one of the brokers at Trafigura thought that there was, in fact, a fixture, even though he was subsequently advised by his legal team to support a case that that there wasn't. So it's not so much about what they thought; it's about what they said and did. Could we go on to the next slide, please? So we talked about subjects, and this is really the crux of this case. And there's a general phrase in shipping that a vessel may be on subjects, and that is generally understood, as it says there, to mean that certain things have to happen before there is an enforceable contract. And this is very much like having a contract that is subject to contract. So until everything is agreed and the parties agree there is a contract, there is no contract. There's often a time limit. Max mentioned just a few hours, and it was the case here that there was only 5 hours for the lifting of the final subject in this case, which was a significant point in the case. Can we have the next slide, please? So, as many of you who know English law will know, English law does not like the concept of an agreement to agree. That is, you cannot say, we will agree to discuss and subsequently agree about something else later. English law requires you to say either you agree to do something or you don't have an agreement and you're still negotiating. So it's either side of the line. It's not in this sort of no man's land of agreement to agree. So in relation to subjects, there are two alternatives. A subject can either be a precondition or a performance condition. And it was really a battle between which of these it was in the case. Can we have the next slide, please? So preconditions, these are things within the control of one of the parties. So one of the subjects there was charterers management approval. Max said, you know, it would go through on the nod, but it's something that is entirely controlled by the charterers. They can decide whether they give approval or not, and nobody else is involved. They have discretion to do it, and they control the decision. This is what is called a precondition to contractual relations, and there is no contract in place until the subject is lifted. Sorry, until all of the preconditions, because of course there may be more than one. The courts have ruled on some further examples of preconditions. If we could go to the next slide. You'll see they've been dealing with this for over 100 years now. So in 1921, I'll just call it, as you can see, the KKKK case, because my Japanese isn't up to being able to say that. It determined the stem, the subject to enough material, is a precondition. The case went on further and made a point which I think, and Sir David will tell me if I'm wrong, but I think is critical to his determination of the case here, that saying that this is something that is entirely within the discretion of the charterer, whether or not they put the cargo on that vessel. So in fact, whether the stem should be lifted is not simply whether or not there is a cargo available, and that has been confirmed by the supplier, but whether the charterer then says, okay, I am still happy to lift the stem. So it's a two-stage process, not sort of a mechanical process that something automatically springs into life when the third party, the supplier, says, yes, you've got the cargo. The judge also raised the point in that case, the KKK case, that shortness of days, i.e. the shorter the time, the more likely it was to be a precondition. Sorry, can we have the next slide, please? The contrast to that, the alternative, if you like, if there's no precondition and the subject is still to be lifted, then it may be a performance condition. There's a number of cases that look at these as well. And the key issue here is that the subject to be lifted is not in the control of the charterers, but is in the control of a third party. In that case, it is likely to be a performance condition, but not absolutely. In this case, the contract will exist, but it will only be enforceable if the subject is met. So you can see a very fundamental difference there. And the classic example of performance conditions in contracts are where the contract is subject to obtaining an export license. So either the export license is granted by a third party or it isn't. And if it isn't, then, sorry, if it is not granted, then performance of the contract is not required. So it may feel like there's not much difference in practice, but there is. Because in this case, the obtaining of the third party approval is controlled by one of the parties, the party who has the benefit of the subject. And nothing will happen unless he takes action on it and to obtain it. So can we go to the next slide, please? So that gives rise to an implied term of the contract that the party with the subject will take all reasonable steps to obtain the relevant approval or license referred to in the subject. So if there's a performance condition, and effectively that is the last thing in the contract, so that there is a contract, then there will be an obligation on the party who's got the benefit of the subject, the party who could lift the subject, to go out and find and to get the relevant approval, the license or whatever that subject is. If he doesn't and fails to act reasonably, that would be a breach of the contract, and it may give rise to damages, although there may not be a loss. There may be a matter to be proved. But again, this is all subject to there being no precondition. So if there are preconditioned subjects, there can't be a contract. So even if there are performance conditions alongside of it, then you won't have a contract. In this case, there was only the one subject left, so there was a very clear and stark choice to be made. Can we have the next slide, please? So back to this case, the subject was subject to supplier's approval. And there was actually a dispute between the parties as the meaning of what that was. Trafigura said that was the approval of the supplier being for Statia Rosneft, whereas Nautica said, no, it's the terminal, i.e. New Star. They had to approve the vessel was capable of being able to come in, and they approved it. Insofar as both of those approvals, either the terminal or the supplier, are third party our third-party approvals, that might indicate a performance condition. And because this was the only subject remaining in the contract, there was no question that there was another precondition which might prevent a contract being formed if this last subject was a performance condition. So now this is where we do the drum roll and we see what the decision was. So if we could go to the next page. And there it is. The decision was that it was a precondition, not a performance condition. Sir David put forward a number of reasons for this, all sort of interweaving together. The original 4 subjects, the compendious phrase of 4 subjects, STEM, suppliers, receivers, and management approval, there was no doubt that the STEM and the management approval were preconditions. And he believed that, held that it would be surprising if the 2 in the middle, suppliers and receivers, had a different status, and that indicated they are more likely to be preconditions than performance conditions. The shortness of time for compliance, in this case only 5 hours, was also a factor. The less time there is to get something done, the more likely it is that there isn't going to be a contract, that the parties will not be bound by what can happen in that time. Further, the fact that there was a dispute between the meaning of suppliers' approval, whether it was the terminal or the suppliers who had to confirm this to charterers, was another thing. Was another issue that pointed it towards being a precondition. If the parties haven't agreed actually what it is that they're trying to achieve, you know, and if it's not clear, like an export license, then we can see that it might be just a hostage to fortune when somebody comes back and says, look, I've got what you want, we're now fully fixed and we can perform, and the other party says, well, no, that's not what I was thinking you meant at all. In those circumstances, it makes more sense for the parties not to be bound until they're clear about what it is that they agree. And the judge made a particular point as well, picking up some of the earlier cases, that the supplier's approval related to matters of the commercial desirability for the charterer of entering into the charter. So it's not something mechanical, like just obtaining the necessary permit or piece of paper for performing the contract. Can we have the next slide, please? So within that, it was held that even if the charterers got the supplier's approval, it was still in their complete discretion as to whether or not the subject will be lifted and for any reason. So it's a two-stage thing and not mechanical. The charterers might, if they got this, they may still find that there's another buyer they might like, another seller rather, they might like to deal with. They might find that because of the change in the market or because of a change in relations with the intended supplier, things have changed. Max and Catherine give a compelling view of how things do change. If you're going to deviate a vessel halfway through, then if halfway through its voyage, then you might equally be willing to drop negotiations with a particular seller through the fixture negotiations and find another cargo if the terms are better. If you could take the next slide as well, please. So the four subjects effectively were all negotiating points for the charterers that indicated the parties were getting closer to contracting, but they were not yet legally binding. The charterers could lift one, some, or all but one precondition, but until all of the preconditions were lifted, there was no binding contract. Therefore, there was no implied term created obliging them to try and obtain the supplier's approval in this case, and if they hadn't wanted to, they wouldn't have needed to. If we go to the next slide as well, please. So what is sauce for the goose is sauce for the gander. The charterers weren't bound, neither were the owners. at any time until all the preconditions were lifted. They could have walked away. Now, there was clearly on the owner's side some surprise about this, and it was a point that was identified in the judgment, that the owners had agreed to hold the vessel for a few hours in order for the charterers to determine whether or not to lift the subject. Now, certainly the owners thought that they would be bound to honour that if the charterers came back within that time, but they were in fact free to walk away if offered better terms elsewhere. And this is one of owners' arguments for saying, well, no, we're bound to do this, for saying that in fact there was a contract. So next slide, please. So in summary, following the thorough review of the case law, it's fair to say that it's now more likely that a subject will be held to be a precondition than a performance condition, even where there's a third party's approval or action is involved. And having talked about this with a number of ship owner clients, they generally take the view that this is probably right, that there's no contract until subjects are lifted. Performance conditions are narrowed down by this. It wasn't popular with our clients, but it doesn't come as a great surprise to the market, perhaps. So in the future, take the view that there will almost certainly be no fixture or contract until all of the subjects are lifted, unless it's a very mechanical subject, like subject to obtaining an export license, where there isn't very much input at all from the charterers and won't relate to their commercial desirability of the contract. Right, and that's me. Last slide, just there. So not so much Jeremy Kyle in this, but I'm sure we can find a few things to argue about. I'd get Mr. Justice Foxton to come back at me and see whether he does.
I think that judges get the last word in their judgments, and so it is only fair that they don't try and grab the last word when people discuss the judgments afterwards. I had my chance for good or ill, and I leave it to others to see what they make of it. But thank you, Alex, for a very interesting presentation. Now, our final speaker is Kaitan Vandovitch, who is a tenant at 4 Pump Court. He is very well known to the Commercial Court because we were very pleased to secure him as one of our judicial assistants earlier on this year, where he worked with the judge in charge, Mrs. Justice Cockrell, and also with Mr. Justice Jacobs and Mr. Justice Bryan. And I hope 4 Pump Court and the LSLC won't mind me doing a brief pitch as to what valuable experience lawyers starting off on their careers can get by coming and working with us as judicial assistants. Now, with the benefit of that excellent preparation that he had working with us, Kaitan has wasted no time in launching his practice. He's got a broad-based practice, including shipping, banking, insurance, construction, engineering. He is going to talk to us about the issue of the battle of the forms as each party looks to impose its own standard terms on the other, including picking up the important recent decision of the Court of Appeal in TRW and Panasonic. So Kaitan, over to you.
Thank you very much, Mr. Justice Foxton, for this kind introduction. It's a pleasure to be here and to address the London Shipping Law Centre audience. The topic of my talk, as the chair has said, is the scenario known as the Battle of Forms. So how does it arise? Can I have the next slide, please? The foundation of English contract law is analysis of offer and acceptance. That analysis has always been artificial in some situations. Boarding a bus comes to mind, multi-party contracts, particularly nowadays new technologies such as smart contracts. But there's still the orthodox way of analyzing contractual relationships. And it's entirely applicable, at least, to any environment in which commerce is carried out by the exchange of communications. Nowhere perhaps more important than international trade and carriage of goods, where contracts are often made by exchange of short emails. English law requires acceptance of an offer to be unqualified. No ifs, no buts. So if prospective charterers offer to owners to take a vessel at $10,000 a day for a year, and owners respond, you can have her for 6 months, they do not have a contract. If owners now deliver the vessel, they cannot require charterers to take her because charterers did not accept the offer, but rather made a counteroffer of their own. And a battle of forms is a scenario where parties do that back and forth with their standard terms. Can I have the next slide, please? Let's take a look at a simple illustrations. We have two companies, buyer co and seller co. Buyers inquire about some goods, sellers say $100 per ton, our terms attached. Buyers send a purchase order for 2,000 tons and attach a note saying on our standard terms, here are our standard terms. Sellers ship it with a note saying no, on our standard terms. Buyers take delivery and pay. That is a battle of forms, and two questions arise. Do they have a contract? And if yes, on whose terms? The good news is that at least to the first question, courts and arbitrators will do all in their power to not answer in the negative. And certainly so if the parties are just in dispute about the second question. English law always seeks to reflect the expectations of commercial men and women, and if between two reasonable business people, one sends the goods and the other sends the price, they will both be much surprised if a lawyer comes about and tells them they did not agree to sell the goods for the price. So the answer to the first question is almost always yes, although it is conceptually possible for it to be no. The real question everyone is interested in is the second question. And that question is normally answered by applying the offer and acceptance analysis that I mentioned, which results in the so-called last shot doctrine. Can I have the next slide, please? I put doctrine in quotation marks because it's not much of a doctrine, it's not even legal principle, it's simply how offer and acceptance analysis operates. And that's well illustrated by the first case, British Road Services and Crutchley. A carrier in that case delivered to a warehouse cases of whiskey for storage. The driver went into the office, announced he had brought the whiskey, and handed over a delivery note saying the carrier's terms apply. The warehouse said, sure, we can store the whiskey, but on our terms, and stamped the delivery note with a stamp saying on the warehouse's terms. The driver unloaded and left, and later there was a dispute about whose terms applied. And the answer is the warehouse's. First, the carrier made an offer to have it stored on the carrier's terms. The warehouse made a counter-offer to store on their own terms. If the driver didn't like those, he could have negotiated further, or indeed left. But he didn't. He took the stamped delivery note and unloaded the whiskey. So he accepted by conduct, because he started performing the contract that the warehouse had proposed. But as I said, offer and acceptance are just a way of analyzing. The question is always what the parties agreed. So if there is evidence that they agreed something different, then the last shot doctrine can be displaced. The second case on the slide, Tech Data, was about supply chain for parts of Rolls-Royce aeroplane engines. The buyers sent a purchase order on their terms, as they had done for some 20 years. The sellers sent the parts required, put their own terms on the delivery note, and the buyers took delivery. The judge at first instance inferred from various factors that the parties really intended the buyer's terms to apply, so the last shot actually missed. And the judge relied on three factors. First, he relied on the commercial importance of various terms as to delivery that were contained in the buyer's purchase orders. Second, he relied on the fact that the sellers had separate contractual obligations to a party behind the buyers, and those obligations specified that the buyers had to get those parts from the sellers, and the terms of that contract with the third party very closely matched the buyer's purchase orders. So it was logical to assume that this is what the parties intended. And also the judge relied on the fact that at no point until the service of the defense, the sellers even mentioned their terms, not in pre-action correspondence, not ever. So the judge concluded from the overall relationship that clearly the parties understood at all times they were trading at the buyer's terms. And the Court of Appeal said no. It held that orthodox offer acceptance analysis can be displaced by very clear evidence of our intention, including from course of dealing, but much stronger evidence of intention would have been required. So here again, ultimately the last shot won, and the buyers took the engine parts on the seller's terms. There are some important implications of that last shot doctrine. First, the orthodox analysis is very difficult indeed to displace. And that will be particularly difficult in contracts made by exchange of emails, which naturally lend themselves to that analysis because they're back and forth communications. And second, if the party firing the last shot is a supplier, it is taking a risk. A seller shipping goods with its own terms may be making a counteroffer, which the buyer is free to take or reject. If the buyer says, I'm not taking the goods on your terms, I ordered on my terms, the seller ends up with the goods that he has to shift elsewhere and can have no complaint against the buyer for refusing to take them. Can I have the next slide, please? And that brings me to TRW and Panasonic. Both global corporations, but the particular entities were English and German. They had a long-standing relationship, and the history is there on the slide. Panasonic's terms were agreed first for all European trading and provided for German law and jurisdiction of German courts. Then TRW made its purchase orders on its own terms, and those provided for English law and jurisdiction. And Panasonic delivered without protesting they did not agree to TRW's terms. So applying the last shot doctrine, TRW's terms should prevail, and their contract should be subject to English law and jurisdiction. And when a dispute arose, accordingly, TRW sued Panasonic in England. And Panasonic said, no, by the Panasonic terms, the parties had agreed to the jurisdiction of German courts. And the court actually found that thanks to the wording of the terms, Panasonic had indeed managed to defeat the last shot doctrine. Here's what the clause said. Can I have the next slide, please? The reason Panasonic came out on top was that its terms, which TRW had signed some years previously, made it clear that they would apply to all future trades, the entire business relationship, unless Panasonic consents in writing to different terms. The clause is clear what it wants to achieve. If there is any counteroffer of different terms by TRW, then any acceptance of Panasonic must be in writing to be binding. And the court found that it does exactly what it says on the tin. Can I have the next slide, please? In the High Court, Mr. Justice Kerr found that yes, if it were not for the clause, then Panasonic making a shipment would likely have meant acceptance of TRW's last shot. The purchase order was an offer, the sending of goods would have been acceptance. But the clause protected Panasonic. And it's worth emphasizing that this is not some sort of legal gimmick or trickery. The court is doing nothing remarkable here, just working out what the parties had objectively agreed. Panasonic long in advance openly and expressly declared, we do not intend to accept any counteroffer by conduct. If you, TRW, see us sending you goods in response to your terms, remember we're not accepting your terms. Do not read that conduct as acceptance. If we want to accept, we shall do so in writing. So in this situation, clearly an objective observer who knows of those terms would not understand Panasonic to agree just because it had made a shipment. And the court was simply giving effect to that. Can I have the next slide, please? TRW appealed with the permission of the judge, and the Court of Appeal in essence said the judge had been spot on, only he should not have given permission to appeal. It is simply very correct, orthodox legal analysis. Can I have the next slide, please? That's why the case is important for businesses and for their advisors, not because of some groundbreaking analysis, certainly not for precedent value, it was just a jurisdiction application, but because it illustrates in practice how one may avoid falling victim to the last shot doctrine. Commercial parties in English law can agree what they want. If they want, they can bind themselves as to the form of any future variation to their contract. It used to be thought that this was not possible, because freedom of contract meant that parties are free to agree to disregard any such agreement to formalities. But that was a fallacy which was decisively put to bed by the Supreme Court in 2018 in the rock advertising case concerning no oral modification clauses, where the court explained that it is in fact precisely because of freedom of contract that contracting parties can restrain their autonomy in this way. The one caveat to this is that if your charter party or other contract is governed by Singapore law, then the Singapore Court of Appeal declined to follow rock advertising. So the situation is less clear in Singapore. There, such clauses are in effect an evidential tool raising a rebuttable presumption that in absence of an agreement in writing, there would be no variation, but it's not quite as clear as it is in England. Can I have the next slide, please? So what are the key commercial lessons that can be taken from those cases and generally from disputes about terms? I would like to highlight three, one for each stage of a disputed commercial relationship. First, before contracting, clever drafting saves headaches. Taking a serious approach to drafting the trading terms pays off. It's not necessarily about avoiding disputes, you might not be able to do that, but about giving yourself the best commercial position if and when a dispute arises. And there are devices which can be used to protect or enhance your commercial position and to which an English court or an English arbitrator will give effect. General conditions applicable to all orders, entering into framework or master agreements, and then trading by means of calling off orders under those agreements. And on a yet more granular level, specific clauses imposing particular formal requirements on future modifications to the agreement. So that's something that businesses and advisors will want to have in mind at the start or renegotiation of a relationship. And of course, as Max has pointed out, you might not be able to force your terms on the other side because it depends on a variety of factors, mostly your commercial bargaining power. But it's something to have in mind, particularly if you have the goods and somebody wishes to buy them. The second key lesson I'd like to mention is clarity with the other side throughout the relationship about what terms apply to what business. On any occasion when the other side's terms of trading come up during the relationship, it is worth asking, are we sure that discussion is limited to the context in which we agree that we trade on the other side's terms? If not, it may turn out that if later there is a dispute, the other party can try and build arguments based on various inferences to be drawn from past references to different terms. TRW and Panasonic at one point had a global discussion in the US about some specific of the TRW terms, with Panasonic seeking certain changes to the TRW terms, even though TRW terms did not apply to European trades, because in Europe, the parties were contracting on Panasonic's terms. But Panasonic apparently gave no thought to being precise about this, and TRW argued that the court should draw from that various inferences about Panasonic's agreement to TRW's terms applying worldwide. If only at the time of that negotiation somebody had expressly put in correspondence, we are seeking amendments to TRW's terms on which we trade outside Europe, then that would immediately have cut off half of TRW's arguments in this case. And the third and final key lesson is know your terms. And this is not limited to the battle of forms. In order to rely on your terms in court or arbitration, you need to have a reliable case on what your terms are and how the other side is said to have agreed to them. And this is not as rare a pitfall as it sounds. I had a case recently where I acted for a freight forwarder in a very long-standing relationship with a major online retailer. A set of general conditions was agreed many years previously, and then orders were sent by short emails as and when needed. And the dispute was about the correct interpretation of my client's terms of business. It was brewing for about a year. There was correspondence, there was mediation, and then, thanks to the diligence of my instructing solicitors, it was discovered that in fact the terms of business on the basis of which all the pre-action stages were had were not the right set of terms. The trade was in fact on the basis of a different revision of the terms. So everybody had to take a step back and effectively restart at a significant cost. Well, how did that happen? Perfectly understandably, actually. The general terms were signed more than 10 years before. In the meantime, there was a major upgrade of the computer systems, migration of the various filing, not all records were kept, etc. And this is a danger particularly in the shipping and commodities sectors with their high pressure, fast-paced trading environments. Fixing so many trades every day, negotiating on the basis of prices changing constantly, on the basis of terms as before with logical changes. Often it's just too frantic an environment to physically be able to do more than short form emails. And if you are a trader or broker listening to this talk, chances are you have commercial relationships going back 10 or 15 years. It may be worth performing a quick mental audit. Do we know what general terms were agreed back in 2005? Do we know if they have been modified since then? Are the people who agreed them still around? How many times since then our systems for keeping records have changed? Computer systems got upgraded, head office has moved, etc. So that's the final lesson from disputes about terms, which I wanted to highlight. Litigation rewards diligent record keeping. It is no use to have the upper hand in the legal interpretation of terms if one cannot persuade the court or the arbitrator, then the other side had accepted them. Panasonic won because it had excellent records. It could evidence who, when, and how signed its customer file on behalf of TRW. The clever drafting, the first key lesson on the slide, made it possible and gave the tools to lawyers in London to argue for jurisdiction of German courts. But they would not have had that opportunity had Panasonic not kept good records. And that's all I had for this talk. I hope I didn't overstep my allotted time. Thank you very much.
Thank you very much indeed, Kaitan. We've had some questions through, and the first question that I wanted to ask Catherine and Max about is raised by Tatiana Jacob, and it is this. Given that there is or may be some difference in view as to what particular subjects mean and how they operate, is there some scope for coming up with definitions that are agreed definitions within the trading community so that when these terms are used in negotiation, everyone is singing from the same hymn sheet?
Can I start by answering that, and then Max perhaps can give his view as well? Singing from the same hymn sheet is not something that traders generally like to do, because they like to seize opportunities where they can see they're not singing to the same hymn sheet, and that's where they make their money. And there's generally been a reluctance amongst traders, and I'm talking about traders here, to get together and agree this sort of terms. It's mainly been driven by the lawyers from the traders' organizations. So I don't think it'll come from the traders. I can see that practically it will be very helpful, but I'm just not sure it will come from the traders themselves. Max, I don't know if you've got anything you want to add from that to that.
I imagine after the Leonidas opinion, most traders are very happy because effectively all the balls are in their court.
Yeah.
So I can't see them wanting to change that whatsoever. Now, and I think it gets quite legalistic in terms of, from a ship owner's point of view, how can he protect himself on a misunderstanding? Actually, this was a question I raised to the panel a little bit earlier. Is it possible for the ship owner to, during the negotiation, say, okay, I agree to lift, if you agree to lift all of the preconditions, but we have suppliers as a performance condition, so the terminal, for example, Valero's terminal, if Valero lifts, give approval, then all subjects are lifted, but they in fact make it a very clear definition. Would that then change this? From a trader, I would feel that that's my commitment I've made, and I'm assuming that, or it feels that that would be enough to protect the ship owner. But I'm going to throw that back to one of the lawyers, or maybe the Honourable Mr. Foxton.
I'm going to pass it on to Alex in the first instance, if I may, but I will then say something about the way in which that issue did arise in the Leonidas.
In theory, yes, Max, but the owners wouldn't have asked the question to say, could we change this to a performance condition and make it subject to terminal approval, because that's what they thought they had. So the doubt didn't occur to them at the time. So if they had thought about it and thought there's a question of doubt here, they would have been able to raise it, but question whether the charterers would have agreed to waive one of the, or to reduce the subjects and effectively say, well, by agreeing this, you are now bound. and you're going to be locked into whatever supply that you're going to be able to get, and if you can't get one, you're going to be in breach. So it's kind of a question that wouldn't arise because not one of the parties didn't contemplate it, if you like. Had they contemplated, the problem might not have arisen in the first place.
But I think you need to find a way that you have an asymmetry of information where both parties understand what they're agreeing to. Because I can also imagine several brokers or traders actually feeling that, yeah, we're done, we're fixed, because the terminal has said okay, and it was quite possibly the legal department then saying, actually, how do we get out of this? You can get out of it.
Well,
I think the second difficulty that might arise is this, that the move from people who have said that they're not in a contractual relationship until they lift the subject to one where they are in a contractual relationship with an obligation to use reasonable endeavors to bring something about is a significant move. And it's a move that the law has generally required a particular level of clarity to effect. It doesn't like the idea that you can accidentally and informally move from subject to contract. It tends to quite like bright lines. And therefore, although posing a question in a seminar, one can articulate it with the precision that would have ticked the judge's box for that, I suspect it's much tougher for commercial parties dealing in real time to do that. I got a question I'm going to ask Kaitan, which is this, that how important was the fact that Panasonic's terms had been signed up to in writing? So you had what the law generally privileges as the best form of consent, a signed document, playing against an argument that by delivery or shipping or acts of that nature, an alternative set of terms had been agreed to.
Well, I would say it's very important. Ideally, we would have all contracts in writing, and in some sectors, sort of financial sector, where contracts are usually made by affixing signatures to a common document, that's easily achieved. It's much more difficult to achieve in trading, but it's there are a number of advantages for commercial parties from signed contracts. One is that signature in English generally signifies consent to that contract, and two, it makes it much more easy to actually evidence the fact that those sets of terms were agreed. And whether or not one could, I'm not sure it necessarily depends on signature, whether or not one could vary that contract by conduct, because the main reason why it couldn't be varied were its terms. I'm not sure if that answer is useful to everybody, but I hope it is the answer that the chair was looking for.
The chair is entirely neutral as to all answers given. Catherine, we've had a question in from Georgi Yorgakiev. I don't know if you're able to read it on the chat, but it's when a commodity buyer is also a voyage charterer claiming damages for the ship owner's failure to load cargo. Does the charterer buyer have to show he's made no actual loss and might have made a profit by not loading the cargo due to having hedged the commodity purchase price, or alternatively due to a falling market where they could buy the same commodity at a lower price? So I think this is really asking generally how considerations of hedging may create a recoverable loss, even though if you simply looked at the transaction independently and on its own, there might not appear to be one.
Yes, the problem with hedging cases is that there are very few, unfortunately, that have actually been heard in the court and reported. But there was a case whereby it wasn't just delay, there were other issues. But in essence, the quantum was based on the fact that the cargo was actually worth more by the time it was delivered. But in mitigation, the trader had actually hedged that cargo movement, and in doing so had lost money on the hedge. And that was decided that they could make the claim, even though the cargo itself had gone up in value. So that was an insightful case, and I'm struggling to remember the name of it, and I'm sure somebody better than me that's perhaps argued it would know the name of the case. It'll come to me shortly, and if it does, I will write it on the chat. But yes, there are cases where they can actually claim for hedging losses, even if the actual contract, the cargo has gone up in value.
So always think about the hedge is your message to
always, yes.
Alex, there's one about arbitration clauses I'm going to throw your way for a reaction, which came in from Charles Holroyd. If you had a negotiation which was still subject to a precondition, one of the terms being bandied about being an arbitration clause, would the arbitrators have jurisdiction to determine whether there was a concluded contract or not?
I think, well, they would have jurisdiction to determine their own jurisdiction under the sort of competence provisions under the Arbitration Act. And so much as I would expect might have been argued at a preliminary level at this stage, where one party is saying there is a binding contract and therefore we have the benefit of the law and jurisdiction clause or the arbitration clause, and the other party is saying there is no binding contract, and whether or not there is a binding contract is critical to the determination of the jurisdiction of the tribunal. The tribunal is bound then to look at the issue of whether there is a contract or not in order to be able to determine their own competence. So it becomes a rather, one party thinks it's restricted to jurisdiction only, but in order to determine jurisdiction, you're going to have to look at the underlying issues to see whether there's a contract in the first place.
Kaitan, what's your thinking about that that question? Do you think that the court could review the arbitrator's decision under Section 67, or do you think there might be a binding agreement to arbitrate, even though not a binding charter party?
Well, I generally agree with what Alex has said. It might arbitration agreements are generally separable, but if we haven't got a concluded charter party, it's difficult to, if it's a question for the arbitrators whether or not a concluded charter party exists. But if we haven't got one, it's difficult to see what else is left.
Thank you very much. I think that may have brought us pretty much to the end of our allotted time slot. So I'm very grateful to all of the speakers for their very interesting contributions. I'm not sure whether there is a silent applause feature on this particular iteration of Zoom, but if there was and I was able to operate it, I would be clapping very loudly at this stage. But thank you all very much.
And it's just for me to wrap up the session. Thank you very much indeed, Sir David. On behalf of Four Pump Court and the London Shipping Law Centre, thank you to everyone who's participated in the session. Thank you, Sir David, for chairing the event so deftly. And thank you to our four speakers who have covered a great deal of ground. I found it tremendously interesting and useful. You've all kept to time, which keeps everyone else happy as well. Catherine and Max, thank you for a fascinating insight into how people actually go about fixing contracts. As lawyers, it's very easy to only see the end result and not really understand how people go about doing it. Alex, thank you for the covering the tricky topic of subjects and doing so with Sir David looking over your shoulder. And thank you, Kaitan, for your excellent analysis of pitfalls and opportunities when negotiating contracts. And lastly, I'd like to thank Gerard at the London Shipping Law Centre and Robin at Four Pump Court for making this evening actually happen. And last of all, thank you, audience, for listening to us, for your questions and contributions. Good evening all, and goodbye. Thank you.
Goodbye.